Good morning and welcome to the South Carolina Public Service Commission. We are here today on docket number 2025-230E, the joint application of Duke Energy Carolinas and Duke Energy Progress LLC to engage in a business combination, address regulatory conditions and code of conduct, and request for a accounting order. Present in the hearing room is Commissioner Belser, Commissioner Brett, Commissioner Caston, Commissioner Whitfield, Vice Chair Williams, and I am Chairman Powers. Joining us virtually is Commissioner Henley. Before we introduce the parties, Ms. Westerhill, if you would please explain this morning's hearing.
Yes, sir. Thank you, Commissioner, and thank you, Commissioners, as well as all those who are present. This morning, as the Commissioner Chairman just mentioned, this is a proceeding in docket number 2025-230E. The proceeding concerns the joint application of Duke Energy Carolinas and Duke Energy Progress LLC to engage in a business combination to also address the regulatory conditions and code of conduct and requesting an accounting order. This hearing was duly noticed by the clerk's office to begin this morning at 10 a.m. on Wednesday, April the 8th. Mr. Chairman, upon inquiry of all the parties, they are present and there is one preliminary matter that needs to be addressed. Otherwise, the docket is ready to proceed.
Thank you very much. Now we would take our introduction of the parties, beginning with Duke Energy's Carolina LLC and Duke Energy Progress LLC.
Good morning, Mr. Chair, Vice Chair Williams, members of the Commission. On behalf of Duke Energy Carolinas and Duke Energy Progress, I am Sam Wellborn. My co-counsel this morning with me are Kamal Robinson, Kathleen Richard, and Nanette Edwards of the law firm Burr Foreman. Thank you.
And y'all always hide her behind the podium. Yeah. We got to get her a high chair or something.
Yeah.
All right. Carolina Clean Energy Business Association.
Chair Powers, members of the Commission, I'm Richard Witt for SECEBA. Also appearing is SECEBA's General Counsel, John Burns, who is admitted pro hoc vice in this docket.
Right. It's good to see you in person, Mr. Burns.
Thank you. Thank you.
Good to be here.
South Carolina Department of Consumer Affairs.
Good morning, Chairman Powers, members of the Commission. I'm Roger Hall on behalf of the Department of Consumer Affairs. Also here today is Carrie Gruby-Leibarker, our Administrator and Consumer Advocate, and Jake Edwards.
Thank you very much. Walmart.
Good morning, Commissioners. I'm Stephanie Eaton here on behalf of Walmart Inc., and I'll make appearances for Carrie Grunman and Stephen Lee also. Thank you.
Thank you very much. Nucor Steel.
Good morning, Mr. Chairman, members of the Commission. I'm Rob Smith on behalf of Nucor Steel, South Carolina. I'm joined by Mike Lavango with Stone, Matthias, Annapolis, and Brew.
All right. Is he here or virtual?
Yes, sir. He's right back.
Okay. Good morning. All right. Sierra Club.
Morning, Mr. Chairman, Commissioners. Robert Guile for Sierra Club. With me virtually should be Isabella Arisa with the Sierra Club's Environmental Law Program.
Thank you very much. South Carolina Coastal Conservation League, Southern Alliance for Clean Energy, Upstate Forever, and Vote Solar.
Morning, Chair Powers. Thomas Gooding on behalf of CCL SACE, Upstate Forever, and Vote Solar. I'm also joined by my co-counsel, Kate Mixon, who is also appearing virtually.
Thank you very much. South Carolina Energy Users Committee.
Mr. Chairman, I'm Scott Elliott. I'm here on behalf of the energy users this morning. Thank you.
All right. And last but not least, Office of Regulatory Staff.
Thank you, Mr. Chairman, members of the Commission. My name is Ben Muschin. With me today is Chad Torrey, and Ms. Donna Rainey is also in second row back there as well.
Thank you very much. Now, there was a preliminary matter we need to address.
Yes, Mr. Chair, was going to take the opportunity, if the Commission would allow, a few minutes to discuss the stipulation that was filed earlier in this proceeding. I know some of the other parties may have some comments as well.
All right, and I have just received an amended stipulation. All right, go ahead.
Okay. How this one works. Is that wrong? Thank you, Mr. Chairman, Vice Chair Williams, members of the Commission. So just to initially address that, yes, there was an amended version that was filed on April 6th earlier this week. to reflect that the Department of Consumer Affairs does not object to the stipulation or does not oppose the stipulation. And so I'll get into that a little bit further as we go. But appreciate the commission letting me take a little bit of time this morning. As I said earlier, my name is Ben Muschin, and I'm one of the attorneys of record for the Office of Regulatory Staff in this proceeding. But I also am proud to serve as its Deputy Executive Director. And so on behalf of ORS, I am pleased to be able to present this morning to the commission for its consideration the agreement and stipulation of settlement that was originally filed on March 6th and then amended on April the 6th. And so just as an initial matter, I think it's important and notable to point out that all of the parties in this proceeding have either signed on to the stipulation or do not oppose its approval by the commission. And no party here today stands in opposition to the stipulation. And so while I said other parties may have some additional comments, I did want to take just a few minutes on behalf of the Office of Regulatory Staff to walk through what I think are some main points of the stipulation and talk about the resolution of some of the real disputes and issues that were presented in this matter. So as a quick aside and to kind of set the table for not only my comments but just this proceeding, I wanted to just point out, you may have seen in direct testimony that the companies in ORS, when we talk about costs, when we talk about benefits, when we talk about those dollars, that we really look at them in two different ways. And so the companies look at it from a nominal basis. And so that's really the cost, the benefits, the value of that at the time it is incurred, whether that be in 2027 or 2032, 2038. They're looking at the actual dollar amount, that cost, without adjustments. When ORS looks at costs and how we typically present things before this commission, we look at it on a present value basis. And so what that does is that adjusts those dollars for the time value of money. What are those dollars worth today in 2026? And so we're really talking about the same things. It's the same dollars. It's the same costs. It's really just how you look at it and whether or not you're making that adjustment for the time value of money. So I just wanted to kind of clear up to the extent there was any confusion on that point. Certainly witnesses can explain it better than I did, but in my comments this morning, I'm going to focus on the present value or the PV basis because that's what our witnesses talk about. So to get into the stipulation itself, as ORS witness Leah Welburn states in her direct testimony, the company's estimated that as a result of this merger, that there will be a cost reallocation and that will result in about an additional $423 million in additional costs to be borne by South Carolina customers. And so, I think it's important to note nobody disagrees that there will be a cost reallocation. That's just fundamentally as a matter of merging Duke Energy Carolinas, Duke Energy Progress, combining those and then reallocating those costs across North and South Carolina after taking into account the wholesale customers. And so there's no dispute that there will be additional costs directly related to the merger. And so, our witnesses, as you can see in direct testimony, we took a different approach. We had, our witnesses had a different analysis and they had some different thoughts on what that cost reallocation amount would be. But as you know, and as we've told this commission many times before, ORS takes its statutory obligation to facilitate resolution of disputes very seriously. And so when we began engaging in settlement discussions, ORS took we started from the standpoint of, okay, how do we know, how can we make sure that customers are not harmed as a result of this merger? That once this merger is completed, once all the reallocations have been done, the customers are not in a worse off position than they are today. And so because of that, we approached the settlement discussions from the sense of, all right, well, let's assume that the company's $423 million is the right number. So then how do you go about addressing that $423 million? And then how do you make sure that there are contributions, that there are enough benefits in order to offset that $423 million such that customers are not harmed in this process. And so, when you look at the company's application and the direct testimony, they propose to satisfy that $423 million really in three ways. So the first two ways are contributions by other jurisdictions. And so specifically, North Carolina retail customers would contribute $95 million of their benefits to the benefit of South Carolina. And then the wholesale customers, the wholesale jurisdiction would contribute to about $223 million. And so when you take those two numbers, the 95, the 223, so that gives you about 318. So that makes up the bulk of that 423 million. But that left about 105 million left for there to make up. Now, in their application, the company said, okay, well, we think that we can make that delta up as a result of the benefits that will result from this merger. And, again, I don't think any party here today, I don't think any of the witnesses that you'll hear from today disputes that there will be benefits resulting from this merger. By virtue of, instead of operating two systems, you operate a single system, you have economies of scale, you have efficiencies, you have, deploying resources, generation, all those things. I don't think anybody disputes that there will be benefits. But from ORS's perspective, the question to us was, well, how certain are these benefits? Duke projects based on the present value numbers, and as Leah Welborn discusses, they projected that the benefits in total for North and South Carolina would be about $1.245 billion. And so South Carolina's share of that would be $220 million. But, our concern was, well, how certain is that? Their projections, we all know projections can be as good as the inputs and the methodologies, but we certainly don't have certainty into what the future may hold. And so, we said, okay, well, what is it that we can do? What can we put in place to make sure that we have at least that $105 million such that there is no harm to customers as a result of this merger? And so, as part of the settlement discussions, that Duke and the companies, Duke and ORS agreed that the companies would guarantee that $105 million. And they're really doing it in two ways. So the first is, I haven't talked this long in a while. The first is through the battery energy storage system. So, the companies right now are operating separately. You have DEC and DEP. And the companies are striving to meet a 22% operating reserve margin. And operating separately, they each are striving to meet that 22%. And so under that scenario, right now, Duke Energy Carolinas projects that to achieve that 22%, that they'll need to construct a 200 megawatt battery energy storage system. In South Carolina, customer share of that is about $37 million. By merging and operating a single entity, Duke Energy Carolinas being the surviving entity, they'll be able to meet that 22% operating reserve margin without the need to construct that battery energy storage system. So we looked at that. That's a real tangible benefit that this merger will provide and helps to offset that $105 million. So then that left about $68 million. And so the companies agreed as part of this stipulation, they committed to achieving $68 million in additional South Carolina retail allocated system benefits. And so how are they going to do that? Well, the companies have agreed to track the system benefits, the costs, the savings over that 14-year period. And so I want to talk a little bit about that tracking mechanism because I think that's important too. So part of the stipulation, we've agreed that Duke and ORS and the North Carolina public staff will be involved too to help develop that tracking mechanism, that methodology. What are the inputs? What are we going to track? How are we going to track it? And, we're going to work together within that first 60 days after the commission issues its order, assuming the merger is approved. and we'll work together to come up with that tracking mechanism. And then we'll bring that back to the commission for y'all's review. Similarly, as if there are problems and we're not able to agree, we'll bring that back to the commission to help get y'all to help us to resolve that. But using that tracking mechanism, if the targeted measurable South Carolina benefits have not been achieved, then the company's shareholders will fund that resulting shortfall. And so between the $37 million of the battery system, between the $68 million in the guaranteed savings from ORS, and with the $95 million from North Carolina retail, the $223 from the wholesale customers, all that together, in ORS's view, that sets the floor of what South Carolina customers will receive as far as benefits. A total of $423 million in contributions and in benefits to offset what the companies estimate will be the additional $423 million in costs resulting from the cost reallocation. So based on that, ORS concluded that that provision, South Carolina customers would not be harmed if this merger is approved by the commission. But I also want to point out, and I think it's important to note, that 423 is a floor. It's not the ceiling. And so, the companies estimate that South Carolina's share of the benefits will be $220 million. And so if the benefits are in fact greater than what is guaranteed in the stipulation, then those additional benefits likewise will be shared by South Carolina customers. So I want to move off just for a second from the cost reallocation piece and then talk about some other aspects of the stipulation. As you've seen in direct testimony, there also was a disagreement about the merger conditions and the code of conduct. Now, as part of the resolution in this matter, ORS and the companies have decided to put aside their disagreements on those issues. We're not abandoning those issues. We're not resolving them. We're essentially living to fight another day. We will each reserve our rights to continue to address those issues in future proceedings, just like we've done in proceedings over the last few years on those points. And so we may still be bringing those issues for you on a case-by-case basis, but we've essentially agreed to stand down on that issue in this proceeding. I also want to talk about a couple of things that I think the stipulation provides that I don't think could have otherwise been achieved but for the stipulation. So in particular, the stipulation does allow the companies to defer South Carolina's portion of the cost to achieve, but it caps that amount at $23 million. In addition, the parties agreed that the companies can come before this commission for an accounting order to establish appropriate regulatory assets and liabilities associated with the share of the benefits mechanism, the cost reallocation impacts, and the cost to achieve. But the companies have agreed that those reg assets and liabilities will only achieve a debt-only return during the deferral period. So those are some specific things. There are two other points that I think are also important for this commission to consider when it's looking at the stipulation. As part of this, the companies have agreed that when they're looking at new dispatchable generation that is incremental to what's in its IRP, that they will prioritize the evaluation of South Carolina sites upon which to construct that dispatchable generation. Now, that's all of dispatchable generation that's incremental, but it specifically talks about nuclear, combustion turbine, and combined cycle generation. And if the companies in that scenario decide to build incremental dispatchable generation in another location in North Carolina, for example, they've agreed to come to this commission and say, here's why we did what we did. Here's why we didn't construct it in South Carolina. And so I think that gives the commission and ORS valuable insight into some of those decisions that may be made by the company. And then along a similar note, the companies have agreed that as employment positions with a material and ongoing nexus to South Carolina operations and customers become available, that they will prioritize efforts to fill those jobs in South Carolina for the next 10 years. And similarly, they'll keep the commission and ORS apprised of those efforts. So in ORS's view, those provisions reflect Duke's agreement to make investments in South Carolina, which can have real economic benefits for the state. Now, there are other provisions of the stipulation I'm happy to discuss and answer any questions if you have. Those provisions are equally as important. But based on all of that, ORS believes that this stipulation is a reasonable resolution of the difficult and hard-fought disputes and issues in this case. Again, I think it's important to note that all of the parties today have either signed on or do not oppose the stipulation. And so on that basis, ORS believes that the stipulation is reasonable. We believe that it is in the public interest, and we recommend its consideration and approval by the commission as filed. And so with that, Mr. Chairman, I'm happy to answer any questions that you or others may have, but would ask at this time that the amended agreement and stipulation of settlement filed on April 6th be entered into the record as the next hearing exhibit.
All right, thank you very much. The amended agreement and stipulation will be accepted in evidence as exhibit number 1.
Mr. Chair. Mr. Chair.
Mr. Vice Chair.
Thank you, Mr. Chair. Deputy Executive Director Mustian, is that new? Or has you been, I may have gotten a LinkedIn notice and didn't pay attention to it.
I'm not on LinkedIn.
Okay.
You can, outside, you can just call me Ben.
Okay.
But it's, I became Deputy Executive Director in December of 24.
Okay.
So a little over a year.
So I'm late to the party. Congratulations.
Well, thank you. I appreciate that.
I appreciate you setting the stage and framing the stipulation. What's understood doesn't need an explanation, so please don't be offended if I don't have any questions during the course of this stipulation hearing. So I appreciate that. Your comments were very helpful to me.
Good. Thank you.
That's all I have, Mr. Chair.
Thank you, Mr. Vice Chair. Commissioner Whitfield.
Thank you, Mr. Chairman. Deputy Executive Director Mustian.
Let's just go with Mr. Mustian. That'll make things much easier.
Mr. Mustian, I didn't, like the chairman said, I just saw the amended version and still kind of wading through things here, and as you might imagine, wading through a lot of this. And if you've addressed it, I apologize, but just now in your explanation, when you talked about if in the future, a future asset were built in North Carolina, you said that the company would come back and to us, to this commission, and discuss their justification for doing so. Similarly, if an asset, future asset, is built here, did you address the future benefits, not only that South Carolina ratepayers would get, but also, obviously, electrons don't know state lines. These assets may, did ORS do a deep dive into the impacts on how, if the asset were built here in our state, to make sure that our ratepayers are appropriately not only benefited, but also the according splits are accounted for, so to speak?
So I guess let me make a couple comments. So first, I want to make clear we're talking about new dispatchable generation that is incremental to what is set forth in the IRP. So we're talking about if there is new, and the company can certainly correct me if I'm stating this incorrectly, but if there is a new project that needs to be built and that is added on to the IRP stack. So I first want to say that
you did say
okay.
You did say dispatchable, and you named, I think, CT's combined cycle
nuclear.
Yes,
yes, sir.
You did.
Yes, sir. So I think to get to the heart of your question, did we do a deep dive as to what the benefits would be to South Carolina customers? The answer is no, because there is no such project today. I mean, we're looking at the merger and looking at it from will customers be better off or worse off if the merger is approved? And so, one of the things which is maybe not as tangible or directly benefiting South Carolina ratepayers for Duke, it does benefit the state of Duke prioritizing, evaluating, constructing that in South Carolina. Now, what the benefits could be, what the impact could be, that's obviously subject to a host of factors, what type of generation we're talking about, where it's going to be built, how big it is. And those things I think would all be appropriately addressed in future proceedings, whether that be a siting act, obviously when they come in for rate recovery, those types of things. So I think that goes a little bit beyond the scope of at least what I think of in this proceeding. But what I can tell you is that their commitment to prioritize those sites, we believe, does provide a benefit to the state of South Carolina if that generation is built.
Well, thank you. I recognize that, obviously going forward, there won't be a DEP anymore, and the two entities, DEC and DEP, of course, have had territories in both states and shared assets for a while. So certainly appreciate your answer. I was afraid maybe somewhere and I had missed something, but you answered it. Thank you.
Yes, sir.
Thank you, Commissioner Whitfield. The one thing that he brought up, Mr. Mustian, is I think when you said about building, if they build in North Carolina, they'll come in and they'll tell us why they did what they did. That kind of means we don't have any say-so on what they're going to do when they're going to do it, even though we're talking about non-existent projects.
Well, so I haven't really thought through that, but I think what I would say is, I don't know that that's any different than today. So,
Okay.
Right now, if Duke decides to build a project in North Carolina, I don't believe that there's any obligation that they come to this commission and ask for approval to do that. Now, with Act 41, there is the ability for them to come and get an out-of-state siting certificate, and I know that there's, I think, a proceeding for 3 of those units right now, but and I don't have it in front of me, but I believe that provision is permissive for Duke to do. So I do think it actually provides some additional benefits of, while they may not have to come to the commission and say we want permission to build it in North Carolina, the stipulation would say, Duke, you need to come into the commission and explain to them why you built it in North Carolina. So it doesn't say that they can't build it in North Carolina. It says they've agreed to prioritize the evaluation of South Carolina sites, to look to South Carolina to build that incremental generation. And then if they don't, to come explain to the commission, hey, here's why we didn't.
Well, and this stuff is very difficult. And you don't know how much I appreciate the work that you do and that your staff does in figuring out a lot of these numbers, particularly when we start talking about the present value of money, South Carolina versus North Carolina. And, I'm sure there's going to be some questions. I certainly have a couple about a 14-year period. How does that affect the present ratepayer? And we'll deal with all that. But y'all have done a great job to reach this point. I congratulate all the parties as to where we are at this point.
Well, Mr. Chairman, I'll just say, and I'm going to steal a comment that one of my good colleagues from across the aisle told me. I've been doing work in front of the PSC for about 21 years now. I've been practicing for 25, which is hard to say, but I think I can say without a doubt this is one of, if not the most complicated cases that I have ever worked on. And so I join you in there's a lot of numbers and a lot of moving parts with this thing.
Well, and I hope when this is all over, it'll be in a situation where when we issue an order that the ratepayers can understand what we do. Commissioner Caston.
Thank you, and Mr. Mustian.
Thank you.
I think you answered about every question I think that I had. So what I ask, if anything, going forward, time will tell. But do the benefits to South Carolina customers that you discussed, does that begin on day one or at the end of the 14 years, or some period in between?
So it was, again, there are witnesses, I think, that can address this more than I will. So take the attorney telling you math with a grain of salt. But so the benefits and the costs will accrue over time. So, and I can't recall the exact table that is in Leah Welburn's testimony right off the top of my head. I want to say it's maybe table 1. I know there's a couple of other ones, and it kind of walks through the benefits that will accrue from 2027 through 2040, and then also the costs that are expected to accrue over that same time period. And so, by the time you get to the end of that 14-year period, then the goal would be that the benefits of this merger have outweighed the costs resulting from the cost reallocation. But it's not like day one, it's $423 million in costs and there's a check that's due. It's over time.
Well, I'd have been surprised if that would have been your answer, but I understand what you said and I appreciate it. Finally, can you address the rationale for opting out of that provision relative to, I think, paragraph C18, relative to, I guess, the demand-side management, in a way that, doesn't, involve discussing the protected settlement discussions?
Commissioner, I don't know that I am best suited to answer that for you.
Well, I suspect Mr. Lawyer.
I believe, if I'm remembering correctly, I think if I'm looking at the stipulation, you're talking about. Let's see.
Well, page 12 on mine. 12,
Thank you.
22.
Paragraph 18, the exploring the expansion of demand response offerings.
Let me find it. That's it.
So if you look at the bottom of that paragraph on page 12, you'll notice it says that the signatories understand that ORS is not signing on to this term and reserves the right to oppose any demand response requests in the appropriate proceeding. I think, are we on the same page with respect to that?
I want to make sure too. Yes.
Yes. So yes. So ORS is not signing on to. We certainly don't oppose that provision, but we're not signing on, and we reserved our rights to make recommendations in future proceedings. So, I think with respect to that paragraph, that would probably be better addressed by the companies and some of the other parties.
I will. Well, thank you, Mr. Mush.
Thank you, Commissioner. Any further Commissioner questions? Commissioner Brett.
Thank you, Mr. Chairman. Mr. Mustin, that was an excellent presentation.
All accolades are welcome and appreciated.
Yeah. Well, it was well done without looking at a bunch of notes. See, you did a great job. And Mr. Bateman, you have a lot of reason to be proud of your team, because I know there are a lot of other people that put a lot of effort into it. And I think that's what, makes South Carolina so special. The hard work that your team does, along with the partners that we have across South Carolina and North Carolina. My question is, you mentioned one thing about that employment period. They're going to seek for the next 10 years to hire South Carolina folks. The question that popped up in my mind when you said that, will we continue to have a president, from South Carolina, like Mr. Pearson and his team, or will that change?
Well, I cannot answer that question for you. I think that's certainly an appropriate question for Duke. I certainly hope that we will still have, as a president of South Carolina, somebody who is situated here, but certainly can't speak for the company in that regard.
All right, so that didn't come up in the negotiations?
No, sir, not that I recall.
All right, and I'll ask that question later, but I appreciate it. Great job.
All right. Thank you very much, Mr. Mustin. We will turn to the other side of the room, and what I've been told was going to be a brief statement.
Mr. Chair, I do have a brief opening statement. I don't have any preliminary remarks specific to the stipulation. I don't know if other parties might ahead of starting opening statements, so I'll defer to you on that, Mr. Chair.
Okay.
Otherwise, I can.
No, go ahead.
Okay, thank you.
We were here last night until about 10. I feel like I'm glued to this chair anyway.
I promise to make this as quick and painless as I can. Good morning again, Mr. Chair, Vice Chair Williams, members of the Commission. I'm pleased to be with you this morning and also pleased that we do have, as Mr. Mustian explained, a stipulation for your consideration in this proceeding. I do want to thank the Commission and its staff for its patience, flexibility, and timely guidance provided throughout the course of this proceeding. That kept all the parties well informed with updated guidance as we work towards a resolution in this docket. We recognize that the spring and the first quarter of this year has been a very active regulatory season for you all and for us, and so we appreciate Commission and its staff's multiple accommodations as we've negotiated the compromise in this docket. The proposed business combination has been almost 15 years in the making. Indeed, in the original 2012 order approving the merger between Progress Energy and Duke Energy Carolinas, the Commission acknowledged that at some point in the future, the companies planned to combine into a single legal entity. As you'll hear from our witnesses today, taking this final step will unlock billions of dollars of system benefits by enabling combined system planning, execution, and operation into the future. We have significant regulatory momentum to this point, supporting the combination. FERC approved it on January 30th, 2026, finding it consistent with its view of the public interest. As part of that approval, wholesale customers voluntarily agreed to forego immediate benefits, contributing $275 million to South Carolina retail customers through a plan to share the benefits of the combination. We then achieved a comprehensive settlement in North Carolina on February 27th, 2026, with the public staff and nearly every intervener in the North Carolina proceeding. A decision in the North Carolina docket is expected by May 1st of this year. And if approved, the North Carolina settlement commits to contribute an additional $150 million to South Carolina retail customers for a combined total of $425 million flowing to customers in the state. In South Carolina, as Mr. Mustian pointed out, a majority of the interveners, including every intervener that filed testimony in this docket, achieved a comprehensive stipulation, and the two remaining parties do not object to the stipulation. So we've made significant progress towards securing the regulatory approvals needed to make the business combination a reality. We're especially pleased to have reached an agreement in this docket even before filing rebuttal testimony, which is a little unusual, but that demonstrates that the parties who studied our proposal closely concluded that the terms are fair and that the combination, in their view, is good for South Carolina customers. With that, I do want to highlight a few of the key provisions in our view of the stipulation that I believe illustrate the value of the compromise achieved and that demonstrate that it would be to the benefit of customers in South Carolina. First, the stipulation includes shareholder guarantees for the targeted measurable South Carolina benefits over a 14-year measurement period. If those benefits are not achieved, the company's shareholders will fund the shortfall. This is a benefit to South Carolina that is secured only through approval of the stipulation. The stipulation also resolves the cost reallocation issue addressed in testimony. The contributions from the share of the benefits plan and the cost reallocation offset work together to protect South Carolina retail customers from the near-term cost impacts of the transaction. The cost reallocation offset itself is comprised of two components. First, the elimination of 200 megawatts of battery storage, as mentioned by Mr. Mustian, that would otherwise be needed, but for this business combination, producing approximately $67 million in South Carolina retail savings. Second, $110 million in targeted measurable South Carolina benefits that are backed by a shareholder guarantee. Taken together, the $105 million South Carolina cost reallocation amount is fully offset. South Carolina retail customers are therefore protected and well positioned to enjoy the planning, operational, and execution efficiency benefits that will result from the combination starting on day one of the combination. Last but certainly not least, the stipulation includes South Carolina-specific commitments, including prioritizing the evaluation of South Carolina sites for future generation assets, prioritizing efforts to fill employment positions in South Carolina over the next 10 years. And like the shareholder guarantees, the companies are accountable to the Commission for those efforts with reporting obligations that ensure that this Commission remains up to date on our compliance. Like the shareholder guarantees, these benefits were secured by and can only be achieved through approval of the stipulation in this case. In closing, I do want to thank the parties, both personally and on behalf of the companies, for their collaboration and compromise in this docket. The stipulation before this Commission is the result of a full and detailed exploration of the company's proposal filed in this case. And while I can't discuss the details of the negotiations with the parties, I can say with confidence that it's with this well-informed view that the parties engaged with each other to discuss a potential resolution, and that shared understanding made resolution possible in this docket. To borrow a phrase from witness Nelson Peeler, who you'll hear from later this morning, this proceeding represents the culmination of more than a decade of work to align DEC's and DEP's systems and processes so that customers can finally and fully benefit from an integrated system. We're close to the finish line, and we look forward to delivering those benefits to the customers that we serve. Today, we'll present our witnesses to you in support of the stipulation. They'll be able to answer any questions that you might have. As our witnesses will demonstrate, and as I believe substantial evidence in the record will show, we believe that the terms of the stipulation are just, reasonable, and in the public interest. Thank you.
Thank you, Mr. Welborn. Any questions or comments by commissioners at this time? All right. Any other party wishing to make a statement at this time?
Mr. Chair, if I could briefly.
Mr. Hall, it's all yours.
Thank you, Chairman Powers, members of the Commission. Again, I'm Roger Hall on behalf of the Department of Consumer Affairs. I just want to take just a couple minutes to explain our position on the settlement. As has already been indicated, DCA has not signed on the settlement. We also have not opposed it. All settlements involve some give and take. They involve calculations of risks and rewards. They take looking at your own testimony and weighing against those of other parties. As you may be aware, the department has a very limited budget in its role here, representing the residential customers before the Commission. And due to our representation in 5 general rate cases this fiscal year, we just simply weren't able to have testimony in this matter. However, our staff, myself and others here today and back in our office, did thoroughly review all the filings, and we had identified one area of concern. So ORS's testimony identified $274 million in additional contributions that were needed to ensure South Carolina customers were fully protected in this matter. The settlement accounts for $105 million of that. So if accurate, ORS's testimony would suggest there is still a potential $169 million in harm. We don't fault any party for joining the settlement, but because we could not reconcile that difference through our discussions with the parties, we just simply could not sign on to it. However, we also do recognize that over time, the merger is going to have benefits for all customers involved, and so therefore, we have not opposed it. So again, just wanted to take a couple of minutes to tell you how we got to our position, and appreciate your time.
Any other parties want to be heard? Okay, well, I guess let's get the ball rolling.
Yes, sir, Mr. Chair. The companies would call Mr. Nelson Peeler and Tim Pearson to the witness stand.
Gentlemen, if you would raise your right hands, please. Do you solemnly affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Good morning, Mr. Pearson.
Good morning.
We'll start with you. Would you please state your name for the record?
My name is Tim Pearson.
By whom are you employed and in what capacity?
I am employed by Duke Energy Corporation as South Carolina president for Duke Energy Carolinas LLC and Duke Energy Progress LLC.
And did you prepare or cause to be prepared 19 pages of direct testimony that were pre-filed with this commission in this docket?
Yes.
Do you have any changes to your pre-filed direct testimony at this time?
No.
If I asked you the same questions that were contained within your pre-filed direct testimony, would your answers be the same?
Yes.
Mr. Chair, I would ask that Mr. Pearson's pre-filed direct testimony be entered into the record as if given orally from the stand.
The pre-filed direct testimony, Mr. Pearson, will enter the record as if given orally from the stand.
Thank you. Mr. Peeler, good morning.
Good morning.
Please state your name for the record.
My name is V. Nelson Peeler, Jr.
And by whom are you employed and in what capacity?
I'm Senior Vice President of Grid Strategy Planning and Integration for Duke Energy Corporation.
Did you prepare or cause to be prepared 35 pages of direct testimony that were pre-filed with the commission in this docket?
Yes.
Do you have any changes to that pre-filed direct testimony this time?
No, I do not.
And if I asked you the same questions that were contained within your pre-filed direct testimony this morning, would your answers be the same?
Yes.
Mr. Chair, I would ask that Mr. Peeler's pre-filed direct testimony be entered into the record as if given orally from the stand.
The pre-filed direct testimony, Mr. Peeler, will be entered into the record as if given orally from the stand.
Thank you. And Mr. Peeler, did you prepare or cause to be prepared supplemental direct testimony consisting of 12 pages that was pre-filed with the commission in this docket?
Yes.
And do you have any changes to your pre-filed supplemental direct testimony this time?
No.
If I asked you the same questions that were contained within your pre-filed supplemental direct testimony, would your answers be the same?
Yes.
Mr. Chair, I would ask that Mr. Peeler's supplemental direct testimony be entered into the record as if given orally from the stand.
The pre-filed supplemental direct testimony, Mr. Pearson, will be entered in the record. Mr. Peeler will be entered in the record as if given orally from the stand.
Thank you, sir. At this time, gentlemen, if you'd please deliver your testimony summaries to the commission, and we'll start with Mr. Pearson.
Thank you. Good morning, Chair Powers, Vice Chair Williams, and members of the commission. My name is Tim Pearson. I'm the South Carolina president for Duke Energy Carolinas LLC and Duke Energy Progress LLC. And I lead Duke Energy's regulated electric utility businesses in this state. My direct testimony supports the company's joint application for approval of the proposed business combination by which DEP will be merged into DEC, creating a single electric utility serving all retail customers in the legacy DEP and legacy DEC service territories. My testimony explains why the combination is good for South Carolina customers, how it aligns with South Carolina's laws and policy goals, and why it represents a practical and forward-looking step for our customers in this state. The energy landscape in South Carolina continues to move at a rapid pace. Customer demand is growing, and the grid is becoming more complex. South Carolina's own Energy Security Act calls for a renewed focus on resource planning and energy security. A single, combined utility will be better equipped to meet those challenges, and the savings that come with it are real and to the benefit of our customers. By way of background, this proposal builds on more than a decade of work following the 2012 Duke Progress merger at the holding company level. Since that time, and with this commission's oversight, the companies have aligned operations and integrated functions wherever possible, including customer billing systems, meter and outage technologies, and back-office support. We have also adopted approaches like the Commission-approved Joint Dispatch Agreement and the One Face to the Market approach to fuel procurement, which have allowed the companies to coordinate more effectively and deliver substantial customer benefits, including more than $1 billion in savings to date. However, despite that progress, there are existing legal and regulatory constraints that continue to require DEC and DEP to operate as separate utilities, limiting the company's ability to fully align planning, execution, and operations for the benefit of our customers. The proposed combination allows us to move past those constraints and fully unlock the value of a combined utility. Importantly, the combination is not just about aligning operations. It is about delivering real savings to South Carolina customers now and in the future. As explained in my testimony, to ensure that South Carolina retail customers do not wait for those savings, the company's proposed plan ensures South Carolina retail customers receive near-term benefits from this combination starting on day one, even before the substantial long-term savings kick in. In my testimony, I also speak to the company's commitment to a smooth transition resulting from the combination, one that respects this commission's independent role, keeps stakeholders informed, and reflects the thoughtful, customer-focused approach that South Carolina expects and deserves. I would like to add that we look forward to presenting our testimony today on the planning and operational benefits this combination enables, the cost-benefit analyses, and the share the benefits plan. As you've heard from council, all parties either support or do not oppose the stipulation. Through the stipulation, the settling parties have also resolved the remaining issues in this proceeding, including the rate integration approach, the regulatory conditions and code of conduct, and the framework for measuring and tracking savings for South Carolina customers. Our witnesses will speak to each of these in turn, and taken together, demonstrate our firm belief that the combination, as implemented by the terms of the stipulation, is in the public interest. This concludes my summary.
Thank you, Mr. Pearson. Mr. Peeler?
Good morning, Chair Powers, Vice Chair Williams, members of the Commission. My name is Nelson Peeler. I'm the Senior Vice President of Grid Strategy Planning and Integration for Duke Energy. I lead the organization responsible for long-term grid planning, including transmission and renewables planning and integration, operational strategy, and strategic projects. This includes the planning necessary to support the operational integration of Duke Energy Carolinas LLC and Duke Energy Progress LLC. In my direct and supplemental testimony, I focus on the operational and planning impacts of the proposed combination and present quantitative analysis of its costs and benefits. From a system operations perspective, DEC and DEP have long been coordinated but not fully integrated. As required by law, we operate as two separate balancing authorities, maintain separate planning reserve margins, and commit resources on a utility-specific basis. That structure requires us to maintain more capacity and reserves than would be necessary if we were planning and operating a single system. And it limits our ability to place resources in the best locations for the combined load. This combination removes those barriers. As a single utility, we would plan for one planning reserve margin for the combined Carolinas load instead of separate margins for DEC and DEP. We would maintain a single set of operating reserves for the combined system, not two, and we would commit resources across the entire fleet to ensure reliability and minimize production costs, rather than approaching commitments separately for each utility. In other words, the combination will achieve lower overall costs for consumers by allowing Carolinas 1U to plan investments in necessary generation and transmission resources more efficiently. Execute those plans more efficiently by siting and building those resources more cost effectively, and operate those resources more efficiently as a fully integrated system. To evaluate the impact of that change, we perform multiple modeling analyses. For purposes of my direct testimony, we use two portfolios from the 2023 Integrated Resource Plan approved by the Commission in 2024, and then compared a two-utility world to a one-utility world. In my supplemental testimony, I provide a third analysis using the assumptions and updated information from the company's 2025 Carolinas Resource Plan currently pending in North Carolina. Across all three analyses, the direction and magnitude of the results are clear. Moving from two utilities to one reduces total system costs by more than $1 billion over the planning period. From a planning and operations perspective, these savings come from three primary sources. First, reduced capacity needs because of a single combined peak and a single planning reserve margin are more efficient than two. Second, more efficient siting of new resources, allowing us to place new resources across the Carolinas footprint where it is most economic and infrastructure is most favorable. And third, lower production costs because a single commitment and dispatch for the combined fleet reduces fuel usage and curtailment. Finally, I want to emphasize that the costs to achieve this combination are modest compared to the scale of the benefits. The integration work, system changes, and related costs are one-time in nature. The savings from more efficient planning, siting, and operation, by contrast, accrue year after year for the life of the new resources and for the combined fleet. My direct and supplemental testimony demonstrates the long-term benefits for South Carolina customers significantly exceeds the cost of effectuating this combination. This concludes my direct and supplemental testimony summary.
Thank you, Mr. Peeler. Mr. Chair, these witnesses are available for questions.
Okay, and it's my understanding there is some agreement about cross-examination.
Yes, sir. The stipulation addresses cross-examination as well as the non-joining parties, I believe, don't oppose the stipulation. So,
All right, so the only questions will be commissioners.
I can't speak for the other. I'm seeing nods.
That's correct. for
Yes, Mr.
Sasiba.
Chair.
Could all the
That's correct
parties
for
confirm
Sasiba.
that?
Yes, sir.
Thank you very much.
Thank you.
All right, Commissioner questions?
I have one.
Commissioner Caston?
You're probably the right one, Mr. Peeler. I'll dream up something for that. No, I'm kidding. Thinking about the savings, which intuitively one would be hard to argue with that. In the past, I've talked about at least my experience, you know, the three fixed costs that were absolute until you could do something with those, you know, people cost, power cost, chemical cost in our case. And I assume that Duke has similar fixed costs that are significant. Will this merger, and I know you've kind of touched on it, but like people cost, will there be over the course of time any reduction in people cost, or is that already accommodated in the current agreement?
So I'll take it. So there are a small percentage of the overall savings, less than 5%, are what I'd say are administrative labor related costs. So for things like we'll reduce the number of hearings in front of this commission, for example, fewer fuel cases, fewer rate cases. So some of those costs that are associated with people labor, but it is a small percentage of the overall savings, single digit percentage. The majority of the savings here are lower capital investments for less infrastructure needed and really fuel operating the system more effectively. So there is a small amount, but most of that overlap of labor has been captured through the previous merger of the companies.
Thank you. And I was going to ask, let's see if I have it. I can't find it, Mr. Pearson, but I was thinking about the question that Commissioner Britt asked, and I was thinking, I wonder if Mr. Pearson's going to have a job after this. I thought,
I hope so.
I'll not ask that.
Yeah.
Thank you. I have no more questions.
Thank you very much. Commissioner Britt?
Thank you, Mr. Chairman. That was going to be my question for Mr. Pearson and maybe Mr. Peeler. You know, I think it's so important here in South Carolina to have a presence from a president of Duke Carolinas and the team that you and the other presidents in the past have had. Means a lot. Same thing with Santee Cooper and Dominion. And as evidence, when we have a public hearing, whether it's on a rate increase or a project siting or whatever, the presence of you and your team, and I think it brings great value and confidence in the ratepayer. So that was my follow-up question. Mr. Mushkin couldn't answer that, and he was right. It should be is the intent for at least the next 10 years or beyond to have a president of Duke Carolinas?
And I appreciate the kind words, Commissioner. Yes, and I would say one of my predecessors is here with me as state president. I think he was the third, which makes me the fifth. I hope that's right. Yeah, that is our intention. I've certainly not heard otherwise. I think what I do know is it has been tremendously beneficial to Duke, and I think the model that we have, where we have someone on the ground, immersed, living, in the state, really understanding the challenges, the opportunities that the state has, and is a partner, every day with the state, which is how I view my role. I think is important. I think I appreciate you acknowledging the team that we have here because I think they're incredible, and I know that they focus every day on doing what's best for our customers here. So I don't envision any future world where that doesn't. I mean, I can't see the future, but that's not the intent of this, and I would or any intent at all. And I think I know it's been valuable to Duke. My hope is that it's been valuable to our customers. I think it's certainly a sign of the commitment that we have to South Carolina, and I expect that commitment to continue.
I appreciate it. And it is all about the people. You know, as Commissioner Casson said, you know, you talk about people, equipment, and, you know, whatever else goes into the cake mix, but it is all about the people. And that makes a big statement, not only to, you know, the ratepayers, but also to the people that look at the companies too and see that. So, and y'all have great people, as do your other utility folks. But so I appreciate it. Thank you.
Thank you.
Thank you, Commissioner Brett. Commissioner Whitfield.
Thank you, Mr. Chairman. Thank you, Mr. Pearson and Mr. Peeler, for your summary of your testimony that you've just provided. Just a quick question, I guess mainly for you, Mr. Peeler. I guess you heard my question to Mr. Mustian of ORS about where he addressed future resources that might be built in another state and this commission having to be informed. You heard me questioning him of that. I guess you were in the room here.
Yes, I was here.
Want to go probably a little bit of an unfair question to him because I was asking him if ORS did a deep dive on something that doesn't exist and something that's not even in the IRP, but certainly wanted to hear ORS opinion, and he gave that. Could you similarly share any insights or comments that you may have, not only any on future assets that may be built in North Carolina that this commission would need to be informed of, or similarly new assets that might be built that, and again, this is very speculative. I understand that because some of the, you know, something that might not even be in the IRP. Could you share how you envision South Carolina ratepayers both receiving both the benefits and how costs would be appropriately allocated?
Absolutely. So the intent here is not to change the way we do that today. That the cost allocation would occur just like it does today. So in the way that works today, whether the asset's built in whichever state, that those costs are ultimately allocated through rates to customers, retail and wholesale customers in both states. That's not the intent to change that at all. The intent of this is to provide some priority for this commission around location of generation, those specific types in South Carolina. And the primary benefit there, of course, is it's indirect for customers, not direct. But it's direct for the state, for the economy, for the investment, the jobs, the tax base associated with it. So it's not a change of cost allocation at all. That's not the intent.
Yes, sir. And he did, Mr. Mustian did mention that Act 41 mentions an asset being certificated out of state.
Correct. Tim, did you want to add?
Yeah, Commissioner, I would say, you know, when we look at where to locate an asset, you know, we look at the benefits to the system, the reliability components. We also look at the lowest cost to our customers. That's not going to change, right? I think the intent of this is those things being equal, right? And we look at two sites for an asset. One's in North Carolina. South Carolina will prioritize South Carolina. So we won't come to this commission and say, we chose South Carolina even though it's X number of dollars more expensive, right? I don't think that makes sense for our customers. But I think if you look at what's happening in Anderson County right now with the CC up there, in fact, last night the company just received its final, you know, third reading on the county council there in terms of kind of the tax structure. I think you can see what benefits locating an asset like that has in those communities. The support that we've had there has been tremendous. I think probably our biggest cheerleader has been the superintendent of the school district, where that plant is going to be located. I think she spoke at the public hearing that a number of you were at. I don't know that I necessarily would have thought a school superintendent would be a cheerleader for a large gas plant, but I think that's kind of the ancillary benefits that are outside of just kind of the rate structure that comes from this. And I think, our goal is to continue to invest in South Carolina. That's what the General Assembly has asked us to do in Act 41, and I think this is just a further expression of that commitment. Again, making sure that we're still doing right by the system and by our customers at the same time.
Well, thanks to both of you for your answers. There's a long and documented history of these assets in both states being allocated appropriately through jury. You've got certain assets, Cliffside, not far across the border in North Carolina. There's been a long history of assets near particularly the ones closer to the state line that we have dealt with over the years. So just want to make sure that going forward that that South Carolina is taken care of. Thank you.
Thank you.
Thank you, Commissioner Whitfield. Mr. Pearson, again, welcome back.
Thank you.
Hope you're feeling well.
I am. Thank you, sir.
And I'm looking at it from a ratepayer who sees this on television or reads it in the newspaper. We talk about near-term benefits. We talk about savings. None of this is going to reflect in their bill. We're talking about indirect rather than direct. Is that correct? Mr. Peeler, I think you may have used that term.
Let me take that,
sure,
Tim. So what I would say is there will be a fairly immediate benefits. So particularly in reduced fuel cost. So on first day we began operating as a combined utility, we will operate the system more efficiently. So we'll be able to commit the combined fleet. There will be lower fuel cost to do that. So the first reflection of benefit for customers will show up in lower fuel. So that will be a fairly immediate benefit. The long-term benefits are the fewer resources to build, and that takes time, right? Because it doesn't accrue until you build or don't build. But be clear, there will be immediate day one lower fuel costs by the ability to operate the combined system in an integrated way.
I think what the ratepayer is asking is, will I have a lower bill?
So the fuel costs will be lower than if it were combined, but the rates are addressed over time, and Witness Elliott's probably the best to talk about the rates themselves, about how they will change over time. But the benefits do begin accruing on day one.
Well, again, the benefit to a ratepayer is a lower bill. You're not saying there's going to be a lower bill.
I'm saying the fuel costs will be lower.
Mr. Chairman.
Which is part of their bill.
Can I help?
Please.
All right. Day one that has been referred to, legal day one, I think it is. The bill that comes out after legal day one is not going to be reduced because of this merger.
It will not be changed.
Okay.
Right.
That's
the fuel part though will be lower. Correct.
When the next fuel case comes around, y'all are maybe hoping, maybe expecting, I'm not sure what the right verb is, that the fuel cost would be lower than had there been two separate companies.
That's correct.
Okay. So it will be after the next fuel case before anybody sees a possible reduction in their bill. Is that correct?
That's correct.
And thank you.
Commissioner,
we have all kinds of ratepayers. We have elderly ratepayers, and we have young people like Vice Chair Williams. So the elderly ratepayer has no concern with what happens 14 years from now. They're not going to benefit from it. And excuse me, the shareholder, they have no involvement until the end of the 14 years. Is that right?
That's right.
And so in no way does this combination affect the stock structure of the company.
No, I can take that. No, the holding company, I think, if you read about or talk about it, some people refer to this as a merger, some as a combination. it's not a traditional merger of two separate holding companies. I think that's part of the reason why what Mr. Peeler discussed earlier about, not a lot of labor changes coming from this, because that's already happened, right? We both DC and DEP are owned by, Big Duke, right? And so that's not changing, the holding company. So it won't change anything around stock or anything like that. I will say, in part as an answer to your question, some of the challenge and what has made this so complicated is what we're dealing with, and what folks pay for now in their bill are what we would call the legacy costs, right? In their bill now is what y'all have approved as we've gone through, has already been built. And so those costs stay the same. They will depreciate over time and so lower in that regard. But what it really is, they will pay, like, their bills will not go up because of, in the same manner as they would have otherwise, because we'll have to build less. And so what Mr. Peeler is talking about is true. And that's a lot of what we are guaranteeing as a company. And so we'll be able to track those and present them to you. But a huge portion of the savings are what we will not build in the future that we otherwise would have had to if we have the two separate utilities. And so I think one of the reasons this is so important to us as a company, there are no shareholder benefits to this. There's no profit component. It doesn't impact us that way. But what it does is, and Mr. Chairman, you and some of the other commissioners and I have discussed kind of the cost pressures that exist as demand on the system grows. And this is a way for us to address that directly. We will have to build less, which is spend less money, which ultimately means not, less impact on customer bills than we otherwise would have to meet the growth that we're seeing. And so that's why we've put so much work into this. It is a direct and meaningful, we've estimated $1.3 billion. I think we feel like that's on the lower end of what it ultimately will be. It's meaningful to our customers. So beyond the operational benefits that it has and allows us to be more efficient, in some ways it's easier for us to run the system that way, it will help us address some of these things that we've discussed in almost every proceeding, because it's top of mind for us and it's top of mind for you.
All right. And I just know years ago when I was young, I took some Duke Progress stock as a fee on a divorce case, and it turned out to be a better fee than I would have gotten if my client had any money. But now all the stock is in the holding company.
That's correct.
And we talk, Mr. Peeler, you talk about savings on fuel. There would be a savings in that there would just be one fuel cost hearing, but you're going to be using the same amount of fuel.
So we'll be using less fuel. So we'll be operating the most efficient plants of the combined fleet. So today we operate them separately. So those two separate stacks first of all, they require more generation because we have to carry a higher reserve margin, and we essentially are serving a larger load for the two separate systems. The coincident load is a little bit smaller than the two separate ones.
Okay, well,
and we get to use the more efficient units to meet that demand. So there will be direct less fuel cost.
Well,
for sure.
Instead of fuel cost, let me just say fuel. You're not going to use less fuel by combination, are you?
We'll use less fuel.
Okay. Yep. All right. And with the war going on, the different things that we're seeing, there's no guarantee that the result of a fuel cost hearing is going to give customers any benefit if prices keep rising, if we keep having the type of turmoil we have.
It will be lower for doing it with one system than with two, regardless of what the price is.
Okay.
So it may not be lower than it is today if fuel prices are higher, but it will still be lower than if we did not combine.
I just can't help think about the lady in the old Wendy's commercial. Where's the beef? If they're saving,
it's a very real savings.
Where's it for the customer?
It's real, and we'll be tracking it and reporting it. So it's a real savings.
All right. Thank you very
Chair
much.
Powell.
Any further commissioner questions?
Chair Powell.
Commissioner Cassidy.
and thinking about this discussion and looking at, I guess, combining some things where cost would be. I'm not talking about getting into rate stuff. I do have a question or two on that. But in many of the public hearings through the course of time, not just recently, but in the past, some customers have commented that, this is just a shell game, start high, knowing that you're not going to get it, you go low, or, the compromise will be a lesser percentage. In this situation, which, again, intuitively just seems logical, and I understand what you're talking about relative to the reduction in the cost and the fuel cost and what's used, because you'll be doing what you said, if I understand it, using more efficient operations or equipment generation rather than being forced to use this. Going forward, and I know it's part of tracking, but with that thought in mind, not saying it's correct that it's start high and settle for lower, but going forward to help hopefully develop that customer confidence that it's not a shell game, or these things are legitimate. And I'm assuming a lot of that would be ORS and DCA and the other interveners too, working with you guys. Are these in the tracking mechanisms? And I read what you have. I don't know how to ask it. What depth of tracking can you really have to show? I mean, what you're talking about, Mr. Peeler, seems very straightforward to me. That should almost be easy to show and verify. But some of the other things like deferred capital expenditures or maybe eliminated capital expenditures, all of that is going to be tracked and verified, correct?
So what we've really proposed, the first four tracking measures are all really fuel related. And if throughout my testimony, we've discussed the challenges of tracking future capital because of the requirement to have an alternate universe, if you will, of what would we have done if we didn't do this. Mm-hmm. That's challenging to track that capital out into the future, which is why we've not proposed that in the initial tracking metrics. We know it will come to fruition, but it's very difficult to put a formal tracking mechanism. And the example I'll give you is the battery, right? The battery that we've removed from the plan, that is a clear capital savings that you can clearly see the approach that with absent the combination, that battery is required to meet planning reserve margin, but we can still meet the planning reserve margin by taking it out. So the capital is more challenging, just like you said, in particularly the further into the future you go to demonstrate that. Although we know it's, like you said, inherently obvious that it occurs. The fuel tracking and daily operational, benefits are much more. There's more ability to track those, which we've demonstrated since the initial Duke Progress merger with our joint dispatch agreement, right? So that's a very similar tracking mechanism that we've done to show the benefits of that, because it's predominantly about using less fuel as well. So we've got experience with that. The RS and public staff have experience with understanding that. So we believe we're going to build on that type of a tracking mechanism to demonstrate that these benefits are real. I don't know if I've answered your question.
You absolutely did.
Yeah, thank you.
I appreciate it. Thank you very much.
Since the stock is excuse me.
Chair, if I may add some questions.
Commissioner Henley.
Hey everyone, thanks for coming in. Just a couple sort of follow-ups and some different ones. Just on the sort of corp structure, I understand it's more of an internal reorg, but you do. Well, it's been a while since I've updated my Duke model, by the way, too. But you do raise debt at DEC and DEP separately today, do you not?
I'm probably stepping a little bit outside of my area of expertise, but the answer is the majority of the debt is issued at the holding company.
Oh, okay. So it wouldn't be any, I guess, combined larger utility operating sub printer. Okay. My other questions are more in the sort of operations. You know, I guess maybe it'd be helpful. Like, so I'm not sure if there's sort of mutual aid kind of rules between states or anything that you can kind of go around with this. But how do you think about sort of having two separate utilities responding to a storm versus the one combined entity from the customers and sort of the emergency response crew's perspective? Is there any change there?
So it's a great question on the storm front. I think the change as it would come to storms would be how the costs are allocated between the two utilities, not in how we operate. This is something that I learned very quickly when I got to Duke. There's this saying, which is very real, is that everybody has a storm job. And that's true. When we have a hurricane or a winter storm, there are separate roles for almost everyone, compared to their day-to-day role. And so that is independent of the two separate utilities. If we have a storm, and we also do a great deal of pre-positioning of assets, and that is done independent of whether they are formally assigned to DEC or DEP. So I don't see any real way that changes. I think Mr. Peeler could talk more about mutual aid in terms of winter storms and our ability to make sure we have enough power and things of that nature. But in terms of a hurricane, for example, we'd operate I think the same way that we do today.
And would that be seamlessly intrastate as well?
Between North and South Carolina? Yes. Yes, and we already do that. We do have periods of time where, and for example, if you look at Hurricane Helene, both Western North Carolina and the upstate of South Carolina were hit very, very hard. And so we had assets, I think, I may get my numbers a little bit wrong here, but we had, 15,000 line workers in South Carolina in the upstate during the height of that storm. They were from all over north. There were Duke folks from North Carolina, Duke folks from Indiana, Florida, all over the place, plus many from peer utilities. But the damage lasted longer in Western North Carolina, up in the mountains. I'm sure you recall the images on TV and things of that nature. And so there certainly were South Carolina folks who went up to help with that once South Carolina power was restored. So, the system doesn't have state lines or doesn't acknowledge them. In times of storms, we go where we needed to go as well.
Yeah, I was just looking at the map to remind myself. I just forgot it's more of a north-south divide than east-west across the states.
Yes.
And okay. That was all.
Thank you.
Thank you, sir. Commissioner Whitfield.
Thank you, Mr. Chairman. It's sort of already been asked or been answered, so to speak, but Commissioner Belser talked to you about the fuel savings would be, while you say day one, won't be realized until the next fuel proceeding when we see exactly where those costs are. And as I understand it, your exchange with the chairman about the using less, and of course I know he was questioning about some world events that may impact fuel costs, but as I've seen it in the past, the JDA, the Joint Dispatch Agreement, you've cited these benefits over these last 14 years, and they are substantial. And as we know, there were tangible benefits for both states. However, if I'm hearing you right, Mr. Peeler, those in the JDA, there will be no DEP going forward, so there'll be no joint dispatch agreement because there's not an entity to have that with. But going forward, whereas you had the JDA, what you're telling me is you won't be maintaining two separate reserve margins, therefore, and you won't even be, in some instances, even running these spinning reserves. Is that correct?
It is. You're exactly on point. The big benefit of, so the JDA is a really good mechanism. It's produced wonderful benefits, but it has limitations. Big limitation is we still have separate balancing authorities. To your point, we hold separate reserve margins required by a NERC reliability standards to do that. And so therefore it takes more reserves, spinning or not, but more reserves. So if they're spinning, more fuel. The benefit of the combination is there's no longer two balancing authorities, there's one. We can commit the units for the full fleet. So today we have to commit them separately, and then we can dispatch them and hold the reserves in the most efficient units. And so lower threshold of reserves, so a lower obligation. And secondly, we'll be able to hold more of those reserves in non-spinning assets. So we have assets like Bad Creek, right, here in South Carolina, which is a fantastic asset because we don't have to burn fuel to hold reserves, right? It's water. So we can release the water and generate. The more reserves we can hold in non-spinning is less fuel. Today we have to hold some of our reserves in spinning assets just due to the nature of the amount and where they're required. So you're exactly right. Lower reserve threshold plus the ability to hold more in non-spinning assets are two of the key things.
Thank you. Commissioner Brett.
Thank you, Mr. Chairman. I just want to ask this question because it keeps flipping around my mind. I come from industry, and if we saw a facility, a competitor, or saw an opportunity to expand to Georgia, Mississippi, Texas, or Virginia, we'd go buy it, and it would make all the sense in the world to combine resources, whether it was from trucking or our field operations teams. There was a benefit to our customers, not just to the ownership of the company. And listening to Mr. Mustin, when he said this was one of the most complicated projects he's been in his 21 years with ORS and I guess 25 years as a lawyer, the benefits are, to me, it's just black and white, ABC, 1, 2, 3. And going back to Mr. Welburn's comment in his opening remarks that y'all been working on this for 15 years. Why has it taken 15 years to get to where we are today?
I would just say, Commissioner, you're not alone in that question. Whenever I talk to some of our friends in the General Assembly, they would ask me the same question, which is, this makes too much sense. Why has it taken 14 years? I think there are a lot of reasons for that. I think Mr. Peeler can probably go into them a lot more. I will say there was a lot of work involved in this, and one of the things that is exceptionally important to us is that our customers don't feel this in any negative way, right? So, beyond squeezing every benefit we could out of the initial merger, we need to make sure we get this right. We need to make sure that our IT systems are prepared and that the way that our customers interact with us and the way that the billing systems work is all done appropriately. And a lot of work's gone into that. And so now we do believe is the right time. And I think I'll turn it over to Mr. Peeler to talk a little bit more about the intricacies of that.
Yeah. So a couple of things. One, it's a great question, right? So we contemplated this when the original merger occurred. I think at the time, the systems, so think billing, probably most complicated, lots of different rates and tariffs and structures and impacts. So being able to make those billing systems move to a common, a single common approach. There's been a lot of work done on all kinds of systems over these past 10 years to help move us along this path. The other thing is the comment about this being the most complex thing. The issues that had to be addressed, while the benefits are clear, I think no one really disagrees with that. It's dealing with the things like the impacts of cost allocation changes and potential impacts to certain customer groups and so forth, so that we can get over that, I'll call it the hurdle, so that everyone can benefit. Working out all those details has really been that's the complexity. It's not what's obvious operational benefit and lower cost system when you're done. It's getting over those hurdles, the tools and technologies, and then I'll call it the rates and cost allocation issues that need the existing things that need to be resolved. And we're in a good place because we've done that, right? With the stipulation puts us in a really good spot. That we've got a path forward here so that we can, to your point, hit those obvious benefits for customers. Thank you.
Mr. Chairman,
Commissioner Belson.
I've been sitting on this, and y'all may not even be the right panel to ask, but with the combined, if this merge is approved in combined system, what's going to be your customer count, approximately?
In South Carolina?
No, across the system.
I think that would be a question better for Ms. Smith, who's coming up a little bit later.
Okay, and this is my concern. Now, when we get a DEC or a DEP rate case or some big case and notice has to go out to the customers, I can't remember if it takes Duke 55 or 45 days to be able to, with bill inserts, bill all the customers. That's a lot in my mind when we're looking at a 6-month period and it's taking 50 to 55 days to get the notice out to customers. Is there a point where you get too big and you can't really manage efficiently the billing, the noticing, everything that has to go out? That's my concern when I see what we're trying to do when we're working with timelines, or one of my concerns. And when y'all go through and you're looking at these billing things, anything y'all can do to shorten that time as far as when we have to do bill insert notices, I think it would be helpful. I'm not trying to increase costs, but I think it's something we need to keep our minds on, if you would. I'm just going to throw that out there for you.
And Commissioner, we certainly will do that. And the point about ensuring that when we have rate cases, for example, folks are getting that information in a timely manner. I will say from my perspective, we already bill all of these customers, right? So our billing, our customer programs, our billing is already done, as a centralized, function, right? So they already bill the combined folks, and we still are able to do that. So I don't think this adds any increased burden on our end in that regard because it's not adding any new customers, right? It's just combining the systems. But I do think we can always do a better job of informing our customers and getting things out sooner. And I commit to you that we'll continue to look at that.
It just seems like an awful lot of, when we're on a 6-month schedule for, say, a rate case, I'm just using that as an example. Now we got it on, well, customers aren't noticed individually on citing cases, but that just seems, that's a big cut in there as far as trying to get things done. So,
yes.
Anyway, thank you.
Thank you.
Thank you, Mr. Chairman.
If I could follow up on that.
Mr. Cass.
Thinking about that question, and I don't remember what you call it right now, but there was, I guess, the update to, it wasn't just the billing system that the company had, but
Customer Connect, is that what you're discussing? Yeah.
Maybe. But it was, in essence, a program or the ability to merge all of your other information systems where you could mine data, not just a billing system, but looking at, I think, a host of other things, including your AMI, all of those things. And I don't remember what you called it, but I remember it cost a lot of money, and it was scattered out over a number of years. To at least it seems to me, or it seemed at that time, with this system, which to me is the magic wand of every utility, a big utility, being able to access the data in all the different business systems you have. That system, if it doesn't do that, I'm somewhat surprised that it does not have the ability now to send that information out to all the customers relatively quickly. Have I missed something?
No, I think you're a little out of my details, but I think Witness Bird, that's going to be up later, can speak a bit about communications to customers and some of the things you're talking about. It's just not exactly in my
I understand it's not mine
scope
either.
here. So, but your points are important, and I think that the method of communicating to customers and so forth about the changes and the impacts to the bill, the view of the bill, those kind of things. I think Witness Bird is the right one to talk to you about that.
Okay, and I will do that because, and I'm not the person to talk about that either because I had the same issues where I was before. I wasn't in my area, wasn't smart enough to figure all that out, but I knew we had all this data, all these different business systems, and it's not very useful if I can't access it and disseminate that information or use that information rapidly. My understanding was that this system that Duke put in was that. And we'll see what Mr. Bird has to say about that. Thank you.
Thank you, Commissioner Caston. Any further commissioner questions, comments?
Mr. Chair.
Mr. Vice Chair.
Good morning, gentlemen. Thank you for being here. I appreciate what you all are doing in terms of trying to offer savings to your customers. Humans are interesting. I don't know if you've ever witnessed a beauty pageant and the comments and criticisms about the contestants from people who would never be able to sniff admission into a beauty pageant. It's just interesting how we are. I know that we have a lot of questions here, but I don't want the questions to take away from the fact that you all are trying to do the hard job of find savings somewhere in a time where affordability is a big issue, and I commend you for leaning forward in that. So what's interesting at this point, and I'm referring to paragraph 10 of the amended agreement, and I'm asking this question based off what was offered during the introductions. The consumer advocate articulated that they don't oppose the settlement agreement. And again, let me be clear while I'm asking this question. I'm bringing the consumer advocate into the discussion because they're charged with representing residential ratepayers who we hear from a lot and who have a constant complaint or criticism regarding affordability. And so they couldn't sign on to the settlement for the reasons that were mentioned. And when I look at paragraph 10, it's noticeable that the consumer advocate is not included in working through the tracking methodology. If I'm paragraph 10, page 7. Page 7.
So I don't, trying to think. We can certainly answer that question. I know I'm coming back up, and I can think about that a little bit more. I think, generally, this DCA is not part of the stipulation. So this stipulation was with ORS and others. I think, we track things, and Mr. Peeler might be able to talk about the JDA and how that's tracked and who's involved with that. But I believe this is relatively consistent with how we do things in the past.
Right. And so I don't have any, this question is not a deep dive question looking for a specific answer. It's really more about observation based on my experience when the DCA didn't exist in proceedings before the commission. And now that they do exist and they advocate for residential ratepayers, again, that we hear from a lot, is it more so now because they're not a party to the stipulation, they are on the outside looking in, moving forward with some of the taskers that are included in the settlement?
So I would say that I don't think I would say that on the outside looking in. You know, part of the tracking will be to present it publicly, right, to this commission and others. This paragraph is directed at how we determine the methodology on the front end. Obviously, it's a dual state system, so we've got to have North Carolina, South Carolina, and the company involved in how that is all tracked, because it hits everyone, both commissions. And so I would say that certainly the Department of Consumer Affairs and any of the interveners or anyone in the public, frankly, will have the opportunity to look at the results of the tracking, and certainly if they believe that it wasn't ultimately we weren't living up to the delivering on the benefits that we have guaranteed, that would be very public. So I think this is just referencing how we're going to track it, not a consistent update as to whether or not we are delivering on the benefits or not. I don't know if that's helpful.
It is. Thank you. And in terms of what the ultimate product will look like, if all the parties to the stipulation agree on the tracking methodology and it's filed with the commission, is your expectation that we will accept that filing as information, or is there expectation for some level of approval? Just wondering what that, in your mind, what that looks like. Because I've been in rooms where everyone's using the same words but have different meanings, have a different meaning for the words.
So I'm reading this, and I think it says that we will file it with the commission if we come to agreement, and then if there are disputed issues, we will file them with you in order to let's see. So you will determine the tracking methodology to be applied for purposes of the stipulation. So I think this reads, I'm not a lawyer, but it sounds to me like it means that if we all agree that we would present it to you, and if there's disputes, then you guys would adjudicate those disputes.
That's the same way I read it. So, and I think that's good to say.
Yeah.
So that your expectations would be met, because I think it would be, in this proceeding, it would be a missed opportunity not to address that, because it could be perceived that filing would be subject to some level of scrutiny by the commission that would lead to a potential hearing for us to vote it up or vote it down. But that's not the way I read paragraph 10B2. 10B3 would be, in the event of a disagreement, then the commission will be called upon to adjudicate. Is that?
That is how I see it, yes.
Okay.
Yes, sir.
Thank you, sir. Mr. Chair, that's all I have.
Based upon that, would there be an objection to adding the South Carolina Department of Consumer Affairs to that by any party, including the South Carolina Department of Consumer Affairs?
Mr. Chair, that's a sort of a fraught proposition, just given the difficulty the parties that joined the stipulation had in coming to an agreement. All parties had an equal opportunity to engage in those discussions, and the stipulation before you is the one that we filed.
Maybe that's something to think about during lunch.
Thank you, Mr. Chair.
All right. Is there any redirect?
Yes, sir. I have just one quick question.
All right.
Mr. Pearson, Mr. Byrd was referenced with respect to the billing challenges or issuing bill notices. Do you remember that?
I do, yes, sir.
Would you concede that Ms. Smith can speak to the logistics in terms of getting bill notices out to customers and the complications involved with that?
I would, yes, sir.
Thank you. That's all I have, Mr. Chair.
Thank you very.
Okay, good.
It's always a good idea.
And Mr. Chair, as is our tradition, I would ask that these witnesses be excused from the witness stand.
Well, certainly can step down, and I think they'll hang around anyway.
Yes, sir.
Thank you all.
We're going to take it's almost morning's gone, but we're going to take a morning break now. And if everyone could be back and ready to roll at 12 o'clock. We're in recess. Good afternoon and welcome back to the South Carolina Public Service Commission. We are continuing the hearing on docket number 2025-230E. We are at a point where Duke is presenting witnesses, and I will turn that over to you.
Thank you, Chair. At this time, the company's called Ms. Rachel Elliott and Mr. Jonathan Byrd to the stand.
If you would raise your right hands, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
All right. Excellent. Good afternoon, Ms. Elliott. I think officially it's afternoon now.
Good afternoon.
Please state your name for the record, please.
My name is Rachel Robinson Elliott.
And by whom are you employed and in what capacity?
I'm employed by Duke Energy Carolinas, LLC, as the Director of Rates and Regulatory Planning.
Ms. Elliott, did you prepare or cause to be prepared direct testimony consisting of 42 pages that was previously filed with the Commission on August 14th, 2025 in this docket?
Yes.
Do you have any changes to your pre-filed direct testimony at this time?
No, I do not.
If I asked you the same questions here today, would your answers be the same?
Yes.
Did you pre-file any exhibits in conjunction with your direct testimony, Ms. Elliott?
Yes, I did. I filed Elliott Exhibit 1.
And Ms. Elliott, did you prepare or cause to be prepared supplemental direct testimony consisting of 10 pages that was previously filed with the Commission on October 3rd, 2025 in this docket?
Yes.
Do you have any changes to your pre-filed supplemental direct testimony?
No, I do not.
And if I asked you the same questions here today, would your answers be the same?
Yes.
Did you pre-file any exhibits in conjunction with your supplemental direct testimony?
Yes, I filed Elliott Supplemental Exhibit 1.
Thank you. Chair Powers, at this time I move that Ms. Elliott's direct and supplemental direct testimony be entered into the record as if given orally from the stand.
Pre-filed direct and supplemental direct testimony of Ms. Elliott will be entered to the record as if given orally from the stand.
Thank you, Chair. And also at this time, I move that the Elliott Direct Exhibit 1 and Elliott Supplemental Direct Exhibit 1 be marked and entered into the record as a hearing exhibit.
The pre-filed exhibits of witness Elliott identified as Elliott Direct Exhibit 1 and Elliott Supplemental Direct Exhibit 1 will be entered as a composite exhibit and will be placed in the record as number 2.
Thank you, Chair. I'll move on to Mr. Byrd. Mr. Byrd, good afternoon to you.
Good afternoon.
Please state your name for the record, please.
My name is Jonathan Byrd.
And by whom are you employed and in what capacity?
I'm a vice president at Concentric Energy Advisors.
Mr. Byrd, did you prepare or cause to be prepared direct testimony consisting of 11 pages that was previously filed with the Commission in this docket on August 14th, 2025?
Yes.
Do you have any changes to your pre-filed direct testimony at this time?
No, I do not.
And if I asked you the same questions here today, would your answers be the same?
Yes.
Chair Powers, at this time, I move that Mr. Byrd's direct testimony be entered into the record as if given orally from the stand.
The pre-filed direct testimony of Mr. Byrd will be entered into the record as if given orally from the stand.
Thank you. And Ms. Elliott, did you prepare a summary as part of your direct testimony in this proceeding?
Yes, I did.
And Mr. Byrd, did you?
Yes.
Thank you. Would you please deliver your summaries at this time, beginning with Ms. Elliott?
Yes. Good afternoon, Chair Powers, Vice Chair Williams, and other members of the Commission. In my direct testimony, I describe the results of the cost-benefit analyses that the companies performed to project the substantial quantitative benefits of the combination. Witness Peeler sponsors the resource planning modeling that was used to evaluate those benefits. I took the results of that modeling and translated them into annual revenue requirements using traditional rate-making tools and assumptions. I then incorporated 2 additional items: the estimated savings that were not captured in the resource plan modeling, such as corporate administrative savings, and the estimated cost to achieve the combination. Both analyses covering the 12-year period through 2038, the end of the planning period in the company's 2023 Integrated Resource Plan approved by the Commission, demonstrate the savings from the combination far outweigh the estimated cost to achieve it. The first cost-benefit analysis showed approximately $1.6 billion in net customer benefits across the system from the combination, while the second cost-benefit analysis showed approximately $3.2 billion. As further explained by witness Peeler, the second cost-benefit analysis was produced using modeling assumptions that are more representative of a future combined resource plan and therefore provides a more comprehensive forecast of potential future savings. I also described the Share the Benefits plan under which North Carolina retail and wholesale customers would contribute a total of $425 million to South Carolina retail customers to help offset the cost reallocation impacts of the combination. In the long term, overall system savings will accumulate and provide net benefits to customers in all three jurisdictions. The Share the Benefits plan acts as a temporary bridge, helping to ensure South Carolina retail customers receive meaningful near-term benefits while long-term savings accumulate. I also described the company's request for an accounting order to establish the appropriate regulatory assets and liabilities associated with the Share the Benefits plan contributions, the cost reallocation impacts, and the incremental cost to achieve the combination. Finally, I provide an overview of how the company currently envisions integrating their South Carolina retail riders over time following the effective date of the proposed combination. Customers will not experience immediate changes to their existing retail rates as a result of the combination. Rather, the combined utility will gradually integrate retail rate schedules over time through subsequent rider and base rate proceedings following the close of the combination, with the timing and the pace of integration determined by the Commission in future proceedings. In my supplemental testimony, I support a third cost-benefit analysis based on the company's 2025 Integrated Resource Plan, covering a 14-year period beginning with legal day 1 through 2040. Like the first two cost-benefit analyses, this third cost-benefit analysis further demonstrates that the savings resulting from the combination outweigh the cost to achieve. In this case, approximately $2.3 billion in net customer benefits across the system from the combination. Although the future is inherently uncertain, the combined results of all three cost-benefit analyses consistently show that across a wide range of model resource plan outcomes, Carolinas 1U provides materially greater long-term customer benefits than the alternative of continuing as two separate utilities. Since the filing of my direct testimony, I am pleased to report that the stipulating parties have reached a stipulation that resolves all issues between them in this proceeding, and I hope the Commission approves it. This concludes the summary of my pre-filed direct and supplemental testimony.
Thank you, Ms. Elliott. Mr. Byrd?
Good afternoon, Chair Powers, Vice Chair Williams, members of the Commission. Again, my name is Jonathan Byrd, and my direct testimony addresses how the companies plan to integrate retail base rates over time following legal day 1 of the proposed combination. I emphasize that the combination itself does not change a single customer's rates. On legal day 1, customers will remain on their existing rate schedules. There will be no immediate change, and the companies are not requesting any rate changes in this proceeding. What happens after legal day 1 is a gradual, Commission-supervised process of convergence over multiple future rate cases. Specifically, in the first combined rate case after legal day 1, the combined utility will propose one set of rate schedules that remain open and are available to all customers regardless of legacy service territory. However, to support a smooth transition and minimize the impact on existing customers after the combination, the combined utility will propose closing certain historic rate schedules to new customers while allowing existing customers to remain on those schedules, with prices on the closed rate schedules increasing gradually over future rate cases as the historic and combined rate schedules converge over time. All proposals regarding closed or combined rate schedules will be subject to full Commission review in future proceedings, and all stakeholders will have full opportunity to participate in those future proceedings. Underpinning the company's approach to rate integration is the concept of gradualism. While the rate designs and prices may be different between the companies at present, the company's approach is intended to produce a gradual convergence over time, ensuring that customers retain rate options and do not experience abrupt or material adverse changes in pricing. In general, the companies are proposing a proven regulatory approach that has worked well in the past with the introduction of new rates or the closure of historic rates, ensuring continuity in rate availability and pricing for many years, and as a result, supporting an efficient transition that avoids adverse customer impacts. I'm pleased to report that the stipulation affirms this approach, committing the companies to gradualism under commission oversight and to a structured stakeholder process before the first post-combination rate case. That is the right framework, and South Carolina customers are well served by it. This concludes the summary of my testimony.
Thank you, Mr. Byrd. Thank you, Ms. Elliott. Chair Powers, at this time, witnesses Elliott and Byrd are available for questions by the commission.
Thank you very much. One quick question while I'm thinking about it, Mr. Byrd. In all the press releases and things that are on the Duke website, it says there'll be no increase in retail rates before 2027. Is that correct?
We have just put into place a couple of rate cases in South Carolina, so rates have been effective for those already in February and March. And so what we're talking about with the business combination, that rate case that I was speaking about where gradualism starts to occur, that would be after that time period. I think in the last rate cases, the company committed to filing a combined rate case within 12 months after the order from this proceeding. Or I'm sorry, after legal day one.
And if I could just add, customers can expect to see no retail rate changes related to the combination. They may see additional rate changes. For example, when I think about our demand side management and energy efficiency rider, those rates usually go into effect January 1 of every year. So they could expect to see an adjustment to that rider, but it's not related to the combination.
Well, then the press release pretty much misleading because it seems to say there'll be no retail rate increases before 2027. Have you read those, or did you write them, or any involvement?
Yeah, I'm not sure I'm clear on exactly what press release you're speaking to.
It's your website. All right. Any commissioner questions?
Chair Powers.
Commissioner Caston.
And I'm not, maybe a question for you, Mr. Byrd. Could be Miss Elliott, but thank you. And I understand the gradualism and, trying to get the rates consistent and common. But thinking about right now where the DEC, has a declining block rate, as I recall. I assume that's still accurate. Is that accurate?
In some of our schedules, yes.
And DEC has an inclining block rate, as I understand it. Is that correct?
I believe, are you talking about on the residential schedule
Yes,
in particular?
yes.
That is true in one of the residential schedules in DEP. There's an inclining block, and it's kind of reflecting some the benefits of a higher load factor for customers who use electric for winter heating. And so DEC has two separate residential tariffs for that. There's one for an all-electric customer, which is a little bit lower, and one for a customer who maybe uses gas heating. And so it's a different design approach to accomplish the same ends.
Okay. So as part of that gradualism, though, any difference whether if DEP has a set that has the inclining block and DEC has more the inclining block with that particular group, I'm assuming one of those is going to go away. It will be working more toward inclining block rate across the system, or similar to DEC's, or what's the thought there?
So I would say that's exactly the topic that the companies would hope to cover in those stakeholder discussions that we talked about in the settlement. So we would have feedback from folks in the room, hear what the desired tariff structures are going forward. And then you are correct, right? We would take one as the go forward rate and keep it open. and then the other ones we would close to new customers. But we would work through that, I hope, in the stakeholder process and be able to kind of get some feedback from folks. And then the company would make the proposal in that first combined rate case as to which tariff to leave open.
Okay, thank you. And Ms. Elliott, you know, there's been much discussion this morning so far relative to measurable benefits. You know, paragraph C8 of the settlement, you know, lists those four measurable benefits. Am I correct that those categories represent the sources of the measurable South Carolina benefits? Those.
So that is four categories that we've agreed to track and measure. That those four categories certainly don't reflect the entire category of benefits that we're projected to see from the combination, but that is a category that we've agreed as part of the stipulation to track and measure.
Well, that kind of answers the second question I was going to ask, if there were other, but I think you just answered that.
Yes, so I talk about it in my testimony. We really have what I've kind of labeled as three categories of savings. We've got the first category that's tied to capital investment, and you heard a lot of that from Mr. Peeler and Mr. Pearson about our ability to be able to defer or eliminate future capital investment. So that's one category of savings. And then we have a second category, which is the production cost savings, so like the fuel savings that Mr. Peeler was talking about earlier. And then we have a third category that's, you know, really more limited category. It's really corporate administrative savings. And Mr. Peeler and Mr. Pearson talked about it earlier. It's very limited because a lot of those savings we've seen since the merger of Duke Energy and Progress Energy. So that's a very limited category of savings. And so these, the tracking and the measuring category is really in that second bucket of the production cost savings.
Thank you. Paragraph C9 in the stipulation, you know, it outlines the process, you know, should the measurable benefits, you know, not be achieved. And it also addresses a scenario in which unforeseen circumstances are determined outside of the company's, I guess, control. Hypothetically, was there a scenario that was contemplated in which the unforeseen circumstances would have or could have or should have been in the control of the utility? And if so, who would pay for that?
So I wasn't necessarily involved in the discussions that gave rise to that particular paragraph, but I think what we're saying is there may be things that happen in the future. We don't know what that could be, that may cause the benefits to fall short due to circumstances not under our control. And so what we're saying is, if that happens, then the burden is on us to come back and demonstrate to this commission that that was something beyond our control. And then the commission has the discretion as to whether or not they agree. And then if you do agree, then there's an opportunity to extend that measurement period to get those additional benefits captured and measured.
I don't think I'm going out on a limb saying that it may be the first time in history that there would be no unforeseen circumstance that comes up through the duration of anything like this. So I anticipate there'll be something here or there on occasion. But as the chair said, if it's 14 years away, I don't have to worry about it. All right, thank you. No more questions.
Thank you, Commissioner Caston. Any further commissioner questions? All right. Thank you two very much.
Thank you.
I'm sorry, is any redirect?
Thank you, Chair. Very, very briefly, I swear, I promise. Ms. Elliott, do you recall questions from Commissioner or from Chair Powers with regards to the press release?
Yes.
Would Heather Shirley Smith be an appropriate witness to discuss that?
Yes.
Okay, thank you. No further questions.
All right, you may step down.
My co-counsel reminded me, Chair, at this time, the companies would ask that both Ms. Elliott and Mr. Byrd be excused. Thank you.
At their own risk.
Yes, sir.
All right. Good afternoon, Chair Powers, Vice Chair Williams, and members of the commission. Chair Powers, at this time, the companies call Alan Hutcherson to the stand.
If you would raise your right hand, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
All right. Mr. Hutcherson, can you please state your name for the record? And by whom are
Turn
you
your
employed?
mic on.
Oh,
There you go.
It's Alan Hutcherson,
all right. Thank you. And by whom are you employed and in what capacity?
Duke Energy Business Services, a principal compliance analyst.
Thank you. And did you prepare or cause to be prepared direct testimony consisting of 8 pages that was filed with the commission on August 14th, 2025 in this docket?
Excuse me, counsel. Would it be okay if Mr. Hutchison moves a little bit closer to the mic or pull that mic closer to him? I can't really
Or
hear
you
him.
can move the microphone. It's
I'm sorry to interrupt.
no problem.
Do you want to do a test real quick?
Testing.
There we go.
Perfect. Thank you.
All right, I'll ask again, Mr. Hutcherson. Did you prepare or cause to be prepared direct testimony consisting of 8 pages that was filed with the commission on August 14th, 2025 in this docket?
Yes.
And do you have any changes to your pre-filed direct testimony at this time?
No.
If I asked you the same questions here today, would your answers be the same?
Yes.
Thank you. And did you prepare or cause to be prepared settlement testimony consisting of 7 pages that was filed with the commission on March 17th, 2026 in this docket?
Yes.
Do you have any changes to your pre-filed settlement testimony at this time?
No.
And if I asked you the same questions here today, would your answers be the same?
Yes, they would.
And does your settlement testimony have any exhibits?
Yes. Hutcherson Settlement Exhibit 1.
Thank you. Chair Powers, at this time I move that Mr. Hutcherson's pre-filed direct and settlement testimony be entered into the record as if given orally from the stand. And I would also ask that Mr. Hutcherson's Settlement Exhibit 1 be marked and entered into the record as a hearing exhibit.
All right. The pre-file settlement testimony and the pre-file direct testimony of Mr. Alan Hutchison will be entered into the record as if given orally from the stand. The settlement, the exhibit identified as Settlement Exhibit 1 of Mr. Hutchison is marked for identification and put in the record as Exhibit number 3.
Thank you, Chair Powers. Mr. Hutcherson, have you prepared a summary of your direct and settlement testimony?
Yes, I have.
Would you please deliver your summary at this time?
Be glad to. Good afternoon, Chair Powers, Vice Chair Williams, and members of the Commission. My name is Alan Hutcherson, and my direct testimony supports DEC and DEP's proposed revisions to the regulatory conditions and code of conduct, which I will refer to as the conditions, that reflect the proposed business combination. I explain how the proposed revisions are primarily conforming in nature and are designed to reflect the combination of the companies. They serve to streamline the documents by removing duplicative provisions, clarifying definitions and responsibilities, and aligning procedures with the new structure of the combined utility. I also explain how the proposed revisions preserve the Commission's jurisdiction and authority to regulate the combined utility. DEC, inclusive of DEP's service territory post-combination, will remain subject to full regulation by the Commission. The Commission in no way diminishes The combination in no way diminishes the Commission's authority to regulate the service quality and rates of the combined utility. In my settlement testimony, I support the provision of the stipulation related to the conditions, and I am pleased that the companies and the ORS were able to work in good faith to reach an agreement on revisions that are limited to those necessary to effectuate the combination, consistent with this Commission's prior decisions. The revised conditions were filed on March 17, 2026, and are attached in my settlement testimony as Hutcherson Settlement Exhibit 1. As a result, the combined utility will operate under essentially the same comprehensive compliance framework as the companies do today. The revisions remain robust. The revisions maintain robust regulatory oversight while making the adjustments necessary for the combination to proceed. This concludes the summary of my direct and settlement testimony.
All right, thank you so much, Mr. Hutcherson. Chairman Powers, at this time, the witness is available for questions.
Thank you very much.
Thanks.
Any commissioner questions? Mr. Hutchinson, on the website, it says that there would, it was proposed there would be no rate increases until 2027. Are you aware of that?
I have not seen that on the website.
Okay, thank you.
Yes.
Hearing no further questions, any redirect?
No, Chair Powers.
Thank you. You may step down.
We would ask that Mr. Hutcherson be excused from the stand at this time.
At his own risk, if we need him, we'll call him, but I think he can certainly step down.
Thank you, Chair Powers.
Mr. Chair, that rests the company's direct case at this time.
Thank you very much. All right. Next, we would go to Carolina Clean Energy Business Association. All right.
Let me try that again. We have no witnesses, Mr. Chair.
All right. South Carolina Department of Consumer Affairs.
We have no witnesses.
All right. I guess Walmart has the next witness. I've got one of these somewhere.
All right, making sure the mic is on.
All right. Mr. Chris?
Good morning.
Good morning. Can you hear me okay?
I can.
Would you please raise your right hand? You solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Your witness.
Thank you. Can you please state your name and business address for the record?
My name is Steve W. Chris. Last name is spelled Chriss. Business address is 814 Respect Drive. That's in Bentonville, Arkansas.
And for whom do you work and in what position?
I work for Walmart Inc. and I am Group Director, Utility Partnerships.
Have you testified before this commission in prior dockets?
I have.
Did Walmart cause to be prepared for docket 2025-230E pre-filed direct testimony dated February 6, 2026, consisting of 12 pages?
Yes.
And by motion filed on March 25th, 2026, do you understand that counsel on behalf of Walmart filed a motion to substitute the pre-filed direct testimony and exhibit of Lisa V. Perry for your pre-filed direct testimony and exhibit?
Yes.
And do you also understand that the commission granted Walmart's motion to substitute your testimony for that of Ms. Perry by standing hearing officer directive dated April 3rd, 2026?
Yes.
With that understanding, do you have any additions, updates, or corrections to your pre-filed direct testimony?
I do not.
If I were to ask you the same questions contained in your pre-filed direct testimony today, would your answers be the same?
Yes.
I move that the commission accept Mr. Chris's pre-filed direct testimony into the record as if given orally from the stand.
The pre-filed direct testimony, Mr. Chris, is placed in the record as if given orally from the stand.
Thank you. Mr. Chris, did you also cause to be prepared for docket 2025-230E one exhibit, SWC1, which is your CV?
Yes.
Do you have any additions, updates, or corrections to exhibit SWC1?
I do not.
I would further move that the commission accept Mr. Chris's exhibit SWC1 as the next hearing exhibit.
The pre-filed exhibit of witness Chris identified as SWC1 is marked for identification and placed in the record as exhibit number 4.
Thank you. Mr. Chris, have you prepared a summary of your pre-filed direct testimony?
I have.
And could you please read that for the commission and the parties in council?
Sure. Good morning, Commissioners. Thank you for the opportunity to summarize my direct testimony filed in this docket and to address Walmart's support for the amended agreement and stipulation of settlement filed in this docket on April 6, 2026. Walmart operates 122 retail units and 5 supply chain facilities in South Carolina, employing over 37,000 associates. In the fiscal year ending 2025, we purchased $2.9 billion in goods and services from South Carolina-based businesses, supporting an additional 14,000 jobs. We're a significant customer of both DEC and DEP, and within those service territories, we have 43 retail stores, 3 distribution centers and related facilities, and we purchase over 162 million kWh of energy each year from the companies. The purpose of my testimony was to address and provide support for the company's proposal to merge DEC and DEP into a single utility. Walmart already engages with both utilities as a single utility, thus a merger would formalize current practice for us. Moreover, we believe that a merger would produce regulatory savings since there would no longer be the need for both DEP and DEC to file separate proceedings. For these reasons, Walmart supports the merger. As the merger will ultimately result in a single set of rates and tariffs applicable to all customers, my direct testimony sought to reach consensus with the companies concerning their agreement in the company's most recent base rate case proceedings regarding when and how they will implement rate design for public-facing electric vehicle direct current fast charging use cases. We are active in the EV charging space with more than 1,200 public DCFCs at over 285 different locations across 43 states, and we've announced plans to build our own EV fast charging network at thousands of our locations across the U.S., including one in Indian Land coming up in South Carolina in the next month or so. In settlements filed in and approved by the Commission in dockets 2025-172-E and 2025-154-E, DEC and DEP, respectively, agreed to meet with interested stakeholders to discuss and evaluate these rate design options suitable for public-facing direct current fast charging facilities. And as a result of that agreement and near-term need for EV charging tariffs, it was our recommendation that the Commission condition merger approval on the company's meeting with interested stakeholders on these rate designs as soon as practicable. Since the filing of direct testimony, a settlement was filed on March 6th, which was amended by the amended settlement filed in this case on April 6th, that provides substantial benefits to the company's South Carolina ratepayers and addresses Walmart's concerns with respect to the timing of EV rate design. Specifically, the companies have committed to propose DCFC EV rate design in their first base rate proceedings post-merger. Walmart views the amended stipulation, which is either supported or not opposed by all parties to this proceeding, as a beneficial resolution of the issues in this case, and Walmart recommends its adoption by the Commission and approval of the merger of DEP and DEC. I appreciate your time and attention to this case, and thank you for allowing me to appear today remotely.
Thank you, Mr. Chairman. Mr. Chris is available for examination and questioning by the commission.
Thank you very much. Any commissioner questions? Mr. Chris, I think you're off the hook.
Great, thank you.
Thank you.
The next party would be Nucor Steel.
No witnesses, Mr. Chair.
All right, Sierra Club. Mr. Gill.
Good afternoon, Commissioners. We have Dr. Maria Rumpani on the line.
All right.
Thank you. Sierra Club calls at this time Dr. Maria Rumpani to the virtual stand. Dr. Rumpani, who are you employed by and what capacity?
May I swear in first?
Yes, please.
Ms. Rumpani, would you please raise your right hand? Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. You're a witness.
Thank you, Chair Powers. Dr. Rumpani, who are you employed by and in what capacity?
I am a founding partner at Current Energy Group.
Did you cause to be filed in this case 43 pages of testimony in both public and confidential version on February 2nd, 2026?
I did.
Did you have an opportunity to review that testimony?
Yes.
Do you have any changes or revisions to that testimony?
No, I did not. I do not.
And if I were to ask you the same questions contained in your pre-filed testimony today, would your answers be the same?
They would be the same.
Chair Powers, I move that Dr. Rumpani's pre-filed direct testimony in both public and confidential versions be entered into the record as if given orally from the stand.
The pre-filed direct testimony of Dr. Rumpani will be entered the record as if given orally from the stand. The confidential version of that testimony shall remain confidential unless or until the Commission rules that such information is not entitled to protection from public disclosure, or if the requesting party agrees that such information is no longer confidential or proprietary.
Thank you. Dr. Rumpani, did you also cause to be prepared and pre-filed in this case with your direct testimony 9 exhibits labeled as MR1 through MR9, one of which was marked confidential, MR3?
I did, yes.
Do you have any changes or revisions to those exhibits?
No.
Chair Powers, I would now like to move into the record both the public and confidential exhibits attached to Dr. Rumpani's testimony as a composite exhibit.
All right. Can you specify which one is confidential?
MR-3.
All right. The pre-filed exhibits of witness Dr. Rumpani as identified as MR1 through 9 or marked for identification be placed in the record as exhibit number 5. The confidential version of MR3 will remain confidential unless or until the Commission rules such information is not entitled to protection from public disclosure, or if the requesting party agrees that such information is no longer confidential or proprietary.
Thank you. And now I ask that Dr. Rumpani be allowed to read a summary of her testimony in light of the settlement agreement that Sierra Club joined in this case.
Certainly.
Thank you. Good afternoon. My name is Maria Rumpani. I am a founding partner of Current Energy Group. In this role and in my previous consulting work, I have reviewed numerous utility integrated resource plans and related applications addressing resource planning issues across the country. I have also previously testified in resource planning proceedings in several states, including before the South Carolina Commission. In this case, I'm testifying on behalf of the Sierra Club. I was asked to evaluate the proposed combination of Duke Energy Carolinas and Duke Energy Progress with a focus on whether this transaction is likely to deliver meaningful and lasting benefits to South Carolina customers. From the outset, I agreed that the proposed combination has the potential to create efficiencies. A more integrated system can reduce costs through improved planning, optimized dispatch, and more coordinated investment decisions. However, the key question in my review was not whether savings are possible, but whether those savings are likely to materialize, and importantly, whether they will accrue to ratepayers. Based on my review, I identified several concerns and developed recommendations aimed at ensuring that those potential savings are actually realized. These recommendations focused on putting appropriate safeguards in place. Specifically, I recommended increased investment in low-cost demand-side resources, expanded deployment of renewable energy, and a clear commitment to a coal retirement schedule. I also recommended ongoing reporting and tracking of realized costs and benefits to the extent possible. While savings are inherently difficult to quantify with precision, transparency is essential to ensure accountability and to enable the Commission to monitor whether the expected benefits are being achieved over time. While the stipulation agreed to by the parties, including the Sierra Club, does not include all of my recommendation, it does reflect progress in certain areas. In particular, it includes incremental investment in demand-side resources, specifically demand response. As discussed earlier today as well, the stipulation also reflects the company's commitment to tracking benefits to some degree. This concludes my summary. Thank you.
Thank you. The witness is available for cross-examination and questions from the commissioners.
Thank you very much. Any commissioner questions? Hearing none, Dr. Rupani, thank you very much for your testimony.
Thank you.
Thank you, Chair Powers. I would ask that Dr. Rupani be excused.
I don't see how I can do much about it. Thank you very much. Next, we have South Carolina Coastal Conservation League, Southern Alliance Clean Energy, Upstate Forever, and Vote Solar. Mr. Gooding or Mr. Mixon?
Thank you, Chair Powers. CCL says Upstate Forever and Vote Solar called John Wilson to the stand.
Mr. Wilson, there you are. Can you hear me okay?
Yes, sir. Thank you.
Thank you. Would you please raise your right hand? Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help?
I do.
Thank you. Your witness.
Thank you, Chair Powers. Mr. Wilson, would you please state your name, title, and employer for the commission?
My name is John D. Wilson, and I'm Vice President of Grid Strategies, LLC.
Mr. Wilson, did you cause to be pre-filed in this docket on February 6th, 2026? Confidential direct testimony comprising 47 pages.
Yes.
Do you have any changes or corrections to your pre-filed direct testimony?
No.
If the questions put to you in your direct testimony were asked at the hearing today, would your answers be the same?
Yes.
Did you also attach to your direct testimony one exhibit labeled Exhibit JW1?
Yes.
Was that exhibit prepared by you or under your direction?
Yes.
Chair Powers, I would now move to have Mr. Wilson's pre-filed direct testimony entered into the record as if given orally from the stand, with the confidential version remaining under seal. The
pre-filed direct testimony will be entered into records if given orally from the stand. The confidential version of Mr. Wilson's testimony shall remain confidential and under seal unless or until the Commission rules that such information is not entitled to protection from public disclosure, or if the requesting party agrees that such information is no longer confidential or proprietary. As to the pre-filed exhibit of witness Wilson, it's identified as JW-1. It's marked for identification and placed in the record as exhibit number 6.
Thank you, Chair Powers. Mr. Wilson, do you have a prepared summary of your testimony?
Yes.
Would you please read your summary for the Commission?
Thank you. Good afternoon, Chair Powers and members of the Commission. My name is John D. Wilson, and I am Vice President of Grid Strategies, LLC. I filed direct testimony in this proceeding on behalf of CCL, SACE, Upstate Forever, and Vote Solar to assess the proposal by Duke Energy Carolinas and Duke Energy Progress to engage in a business combination, identify potential issues the Commission should consider in deciding on the application, and provide my opinion about whether the proposed merger is in the interests of customers and consistent with Duke Energy's prior commitments and other proceedings. My direct testimony concluded that overall, Duke Energy presented a reasonable framework for merging Duke Progress into Duke Carolinas, but I identified several concerns or areas for further consideration. Specifically, I recommended that the Commission, 1, direct Duke to file a detailed plan for aligning customer rates. 2, direct Duke to provide a compliance filing explaining whether it has adopted cost minimization practices that fulfill all of its 2012 merger commitments. 3, require Duke to establish ride-through studies and performance requirements in large load interconnection requirements. And 4, provide the company with guidance regarding how share the benefits revenues should be allocated to benefit South Carolina customers. While I have not reviewed the stipulation in detail, I understand that CCL, SACE, Upstate Forever, and Vote Solar join the stipulation in this proceeding, except for one term, and believe it to be a reasonable resolution of the issues in this case. Thank you.
Thank you, Mr. Wilson. The witness is now available for questions from the Commission.
Thank you, Mr. Gooding. Any questions for Mr. Wilson? Hearing none, thank you very much for your testimony.
Thank you, sir.
Thank you, Chair Powers. And I would ask that Mr. Wilson please be excused.
I can't stop him. All right, we're at a point where I think the remaining witnesses would be the Office of Regulatory Staff, and I guess it would be a good time to take a lunch break. I would ask, before we hear from Office of Regulatory Staff, if any commissioners wanted to hear from any more of the witnesses from the company. No request? Okay. We will then, well, I mean, we do have the settlement testimony, but anything further besides that?
Mr.
Okay.
Chair.
All right.
Mr. Chair, could I just ask a housekeeping matter before we break? So as the Commission is aware, one of our witnesses, Mr. Robert Lawyer, has had some health issues, and so we had asked that his testimony be entered into the record with the agreement of the other parties of record. I filed a verification yesterday and just wanted to make sure that that was acceptable to the Commission if we proceed in that manner.
Well, yes, and I hope he gets along well. There's no objection from any party. We will certainly accept his testimony with the verification.
All right, thank you,
Thank
Mr.
you
Chair.
very much. All right, we're going to take lunch. Let's come back about 10 till 2 and wrap this thing up. Thank you very much. We're in recess.